Clause 24 of PEN Contract 2018 is about the loss and/or expenses caused by the matters affecting the regular process of the work. You may refer to the PEN contract document for the full statement. There are 4 sub-clauses, and there are a lot of sub-components within some sub-clauses. The relevant information has been simplified in these slides. Now let us talk about the Clause 24. It is related to situations, or it is termed as the matters that affecting the regular process of the work. As a result of this matter, some losses or expenses incur. In most of the case, whatever happened in the site will be imposed onto the contractor. The contractor is providing service to deliver the work as per stipulated by the contract. Whatever is happening on site, the contractor will have to resolve them. However, there are some cases which the losses and the expenses shall not be imposed onto the contractor. This clause will allow the contractor to claim for the cost. Similar like the clause 23 regarding the extension of time, there are certain cases which the contractors are entitled to claim for the costs and expenses, and we shall discuss about this later. Now, the contractor may claim for the loss and the expenses provided that the contractor apply for the claim. When such a manner occur, within 28 days from the architect instructions or confirmations of architect instructions, or by the start of the matter, whichever is earlier, the contractor will need to write notice to the architect showing the intentions to claim for the expenses or the losses. Together with the written notice to the architect, necessary calculations should be provided. That means there will be an anticipated amount incurred regarding the claim. This one is when the matters occurs, and the purpose here is to show the intentions to claim for the expenses. This is to make known to the architect and the employer so that they are aware of that and prepare for the claim. Then at the end of the matter, within 28 days after the matter ended, the contractor should submit the claim to the architect and the quantity surveyor, the complete particular of the claim plus the necessary calculations. By this stage, the matter has been ended. The calculation should be certain on basis of the real case, and the relevant claim should be done within 28 days after the matter ended. After 28 days, the relevant cost should be fully backed by the contractor. The claim shall not be entertained. Now, the eligibility of claiming for those expenses, it will be subjected to the matter as listed in the clause 24.3, which is this. And also, it is provided that the contractor is entitled for the claim under the common law. Now, the definitions of these 28 days, if in accordance to the PEN contract, it is referring to the calendar day including the weekends. However, it is excluding the holidays in the locations of the work. Having the claim submitted to the architect and the quantity surveyor, the architect or the quantity surveyor should ascertain the amount of loss and or the amount of the expenses. Now, if the interim certificate has been issued before the date of ascertainment, that means the relevant claim has not been incorporated within the interim certificate. Now, the relevant amount should be added to the contract sum. If the amount ascertains before the interim certificate, that means the interim certificate happens after the date of ascertainment, the relevant cost should be included in the interim certificate. For your information, the interim certificate will be the progress payment certificate issued by the architect. It states the amount payable to the contractor during the interim claim. Next, we look at the matters that are claimable. You see a list here for the matters. It is quite similar to the list in clause 23.8 regarding the extension of time. However, the numbers of the item here is less than the extension of time. You can make direct comparison between the list of the matter here, which is claimable for the loss and expenses, against the list of the relevant event for the extension of time. You will see that the numbers of items here, it will be slightly less. So when you compare the relevant event for the extension of time and the matter claimable for the loss and expenses, these are the common lists. All of these matters are entitled for the extension of time, as this matter indeed affecting the regular process of the work. You know the principles of having the extension of time shall theoretically be the same with the principles that the contractor is entitled to claim for the loss and expenses. Ultimately, it shall not be due to the negligence of the contractor. Otherwise, the contractor is not eligible for the extension of time as well as the claim for the expenses. Since we have discussed about the relevant event for the extension of time one by one previously in our previous video, we shall not go into item by item for the list of the matter. Probably you are wondering regarding the list of the event which only appear in the relevant event for the extension of time, but is not in the list of the matters which is claimable for the loss and expenses. In another word, under what circumstances the contractor may claim for the extension of time but cannot claim for the loss and expenses. By comparing the two lists in clause 23 and clause 24, these are the lists of the event only happens under the relevant events of extension of time. In another word, these scenarios are not claimable for the loss and expenses. Or more precisely, the contractor cannot claim for the losses or expenses under these circumstances from the employer. PAN contract do not provide the rationales. Why is it so? But if we look at the list of the events which are entitled for the EOT but not entitled for the claim for the loss and expenses, you can see the rationales behind. The first group, it will be due to the irresistible compulsions or superior strike. This is something neither the negligence of the contractor nor the negligence of the employer. Nobody would hope for this to happen. In the case of any of this happen, allowing the contractors to claim for the employer, it would be unfair to the employer. As a result, no claim should be made from the employer. When any of this happen, the extension of time may be granted. so that the contractors are not being imposed with the liquidated damage as a measure to ensure the fairness to the contractor as well. Next is related to the loss or damage related to the CAR insurance. CAR insurance refers to the contractor or risk insurance. In the case any of this happen, the claim should be made to the insurance company, but not to the employer. Therefore, this item is not in the list of the matters that is claimable for the loss and expenses. Next, it is with the compliance to the architect instructions under clause 11.2. The relevant claim should be entitled with the variations orders. And when come to the clause 1.4 regarding the discrepancy and divergence between the document, theoretically this should have been detected before the commencement of the affected work. The contractor will need to notify the architect and wait for the instructions from the architect or clarifications from the architect, which is the right information. As a result, no monetary loss or expenses shall incur. The only things that will involve it will be the durations spent waiting for the response from the architect. Next is about renominations of the subcontractor. Again, this imposes no monetary loss to the contractor. It is only related to the durations. As a result, the extension of time shall be given. Next, if you look at the two items here, it is related to the appropriate authorities and service provider. This shall not entitle for the claim for the losses and expenses, as by default, it is the obligations of the contractor to fulfill and comply with the statutory requirements. In the case that there are latest updates in terms of the laws and requirements, this shall fundamentally assume to be a part of the obligations of the contractor. Now, in the case there are delays caused by the appropriate authorities or service provider, it is likely that no monetary loss shall incur. It is purely related to the delay only, and therefore the claim for the losses and expenses it will be irrelevant. These obligations of the contractors to comply with the statutory requirements is in line with the principles as per stated in clause 4. It is clearly stated in clause 4, the contractor will need to comply with all the laws and regulations concerning the executions of the works.